Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There is some breaking news today on two fronts with the filing of one document in the Idaho versus Kohberger case. It is the notice of filing affidavit in support of defendant's objection to the state's motion in Limine regarding AT&T Timing Advance records. This is a defense filing. It is in support of one of the in limine motions that the defense is opposing that was filed by the state of Idaho regarding AT&T Timing Advance records. This is the Affidavit of Defense Expert Witness Sy Ray. What I'd like to direct your attention to, ladies and gentlemen, is what is it being produced for and what is it not being produced for. We see right here. This is to oppose the in limine motion as to AT&T Timing Advance records, but I see nothing here regarding alibi defense. By way of background, in 2023, the state of Idaho served discovery upon Mr. Kohberger. The state of Idaho says, if you as a defendant want to raise the defense of alibi, saying, I could not have committed these crimes you are charging me with because I was elsewhere, and I can prove I was elsewhere, but what the statute requires is witnesses who could corroborate that a defendant, for example, was not in Idaho, but was on a beach, on a vacation, and witnesses can come forward to testify that they were with him, or the hotel manager at the hotel in Hawaii could come forward and say, yes, defendant Smith or Jones or whomever was in Hawaii on the day of the crimes. And here's the evidence. He's caught on cameras that we have in our hotel. I interacted with him personally multiple times during the week. He was in Hawaii. That's an example of an alibi defense. What Mr. Kohberger was attempting to do as a partial corroboration was to introduce Mr. Sy Ray, an expert witness who does not have firsthand knowledge. He can't get on the stand and say, Mr. Kohberger was not at 1122 King Road on November 13th at the time in question. He was looking to introduce an alibi defense corroboration through technology. And the state had demanded, that's one of the in limine motions, if Mr. Kohberger is going to continue to raise a defense of alibi, he needs to get up on the stand, and that would subject him to cross-examination. The defense came back, and what they wanted to do was to have Mr. Ray provide live testimony, which for such an unorthodox type of alibi defense, you would think that he would need to be in the courtroom, available for Judge Hippler to see in person, provide in-depth testimony as to why this technology should be used in support of an alibi defense as opposed to someone who has firsthand knowledge. Judge Hippler declined, said, your witness, Mr. Ray, if we have any questions for him, have him stand by, and we can have him come in via remote technology. But here we see no mention of Sy Ray providing testimony in support of alibi defense. We, of course, will wait to see what His Honor Judge Hippler rules on the 9th and 10th of April during these critical hearings on all of the in limine motions. But let's look at what Sy Ray has to say for the defense regarding the AT&T timing advance records, which is what this affidavit, sworn testimony, evidence is being produced by the defense to say. Well, we see here Sy Ray's affidavit. And it says here, Affidavit of Sy Ray regarding AT&T timing data. It says at the top, you'll see State of Arizona, County of Maricopa. That's where he is when he's executing, when he's signing this under penalty of perjury. He has to give some introduction statements, and that's where he say, I'm an adult over age of 18. I have personal knowledge of the facts set forth within this affidavit. That's what we're talking about when we say with the alibi defense, saying here he has personal knowledge of the facts set forth herein. He gives a little bit of his background. He refers to his curriculum vitae previously provided. He gives his background here in paragraphs 3 and 4 to try to persuade Judge Hippler he's an expert in this field, Judge. He talks about what timing advance is. Timing advance records are maintained by cellular network providers that provide a time measurement. This time measurement refers to the amount of time it takes a radio signal to travel from a cell site to a mobile device and back to the cell site. Given this signal travels at a known constant speed of light, in parentheses, it is possible to use the measurement to determine the distance the mobile device is from a known cell site. That's the bottom of page 2. Going into page 3, he says, AT&T timing advance. In August of 2021, I was approached to assist in analyzing a type of record set identified as AT&T timing advance report, and it was the first time I was made aware of this type of data from AT&T. He then goes into what AT&T timing advance did not do. Then he says he gives information about his AT&T legal demands. During his career, he's worked with call detail records from every cellular provider in the United States. I've been involved with thousands of cases which call data records are obtained from these companies. So he's showing he's got quite the background in this field. Now, bottom line, we go into page number 4 and 5. And what he is basically saying here is that there is evidence in direct contradiction with the state's motion. He says, in my review of this investigation, I have read numerous emails sent and received by law enforcement pertaining to their investigation. One such email dated November 15th, 2022. This would have been 3 days, ladies and gentlemen, after the crimes, to give us a timeline here as to when this happened. He's saying here that he read this email, and what it says is it was sent to Prosecutor Jennings at her Latah County government email address. The email was from Moscow Detective Lawrence Mallory. The email is informing Ms. Jennings of Detective Mallory's recent contact with the feds, and that Allen's informed Detective Mallory that AT&T can provide timing advance data and to make sure it is listed in the search warrant. Detective Mallory is specifically asking Prosecutor Jennings to make sure the AT&T timing data is listed in the warrant prior to the report ever being distributed by the working group known as GLDC. Ms. Jennings, according to Mr. Ray, did respond to Detective Mallory's email inquiring on specific verbiage needed to obtain AT&T timing advance. This email is abundantly clear, according to Sy Ray, that Ms. Jennings was not only aware of the existence of AT&T timing advance in 2022, but also shows her intention to obtain it through legal process from AT&T. Legal process would be getting a warrant for this information. Now, he says here that based on his training and experience, it is incredibly unusual that the defendant's AT&T timing advance records were not obtained So he is calling into question this information. When it comes to location data from AT&T, timing advance data can be some of the most accurate data available. Additionally, it contains connections to the network other than the typical voice, text, or data connections. This allows law enforcement to not only see more data, but more accurate data. Anytime a defendant's location are in question, timing advance report would be asked for as a standard operating procedure. Moscow Police Department was aware, demonstrated that they were aware of this standard procedure when they obtained AT&T timing advance data on over 3,800 mobile devices. Bottom line, paragraph 6, page 6. It is my expert opinion AT&T timing advance data did exist for the defendant's AT&T mobile device in 2022, and it was requested from AT&T by the investigators involved in this case. The investigators previously demonstrated their ability to obtain AT&T timing advance data in 2022. Failure to produce the defendant's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release in discovery. He concludes, it is my expert opinion in reviewing all of the evidence that has been disclosed by the state that AT&T timing advance data was available on the defendant's phone in 2022. Should have known that this information did exist. I am prepared to provide witness testimony and relevant exhibits that support all of my opinions contained within this affidavit. He says, it is my belief this evidence is beyond clear and convincing and will be supported by any competent expert in this field who reviews all of the data. This is not a battle of experts. That's what usually happens when you have one expert says the sky is blue, the other expert says the sky is gray. There's a battle of the experts for the trier of fact to determine which one is more credible. He's saying here, this is not a battle of the experts. It's clear cut. The evidence supporting the opinion in this affidavit is overwhelming, he says. Then he says, in my nearly 30 years of working with and for prosecutors, because he's a former law enforcement official, and this, we understand from his prior testimony, is the first time he's ever serving as an expert for a defendant. And that's why he says here, in my nearly 30 years of working with and for prosecutors all over the United States, I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and the defense. It rises to a level beyond a simple miscommunication or oversight and is clear and intentional misrepresentation in the hopes to conceal a much larger issue. I respectfully request the court give this affidavit the due attention it deserves, and explore these issues further. Dated the 25th day of March, signed under penalty of perjury by Sy Ray. And it is now, his signature here is sworn and subscribed to by the notary public. We see there the commission. Explosive information on so many fronts here, ladies and gentlemen. This now leads me to wonder if the court is going to have Mr. Ray give live testimony for the defense to explore what he's saying here, misconduct basically, more thoroughly, and also provide the state of Idaho with an opportunity to cross-examine him on each and every point he lists here. Time will tell. Please continue to stay tuned to the Indie Zone. We will continue to provide you updates as they come about in this case, Idaho versus Kohberger. This is Kathy. Thank you for joining us here today.